Balaki, where is Balaki at?
My name's Blake.
Do you want to go to war, Balaki? I'm for real. Ron.
Ron is here, everyone, and we are ready for war, Balaki. And I'm joined once again by the amazing Zach Morgan, my lawyer friend, Zach Morgan. He can be your lawyer friend, Zach Morgan, as well. Check out his YouTube channel, Your Lawyer Friend, Zach. How's it going, man?
Hey, we're good. It's cold. So hopefully your weather in Florida is better than it is here. So we're all hunkered down because we don't do well in the cold in the South. But other than that, it's fantastic.
That is awesome. Well, we are here today to discuss the update in Leah Remini's lawsuit against Scientology. Scientology's sticking to their normal legal strategy playbook. Delay, anti-SLAPP lawsuit. Leah's fighting the anti-SLAPP. The judge has issued his tentative ruling on this anti-SLAPP issue. I got to defer to you on this stuff, even more so than normal, because I tend not to understand a thing about these anti-SLAPP initiatives. What can you tell us about this and what's happening?
Sure. So let's take a step back to make sure everybody's with us. So anti-SLAPP protection. SLAPP is an abbreviation for strategic lawsuit against public participation. And they became a tool basically to intimidate and silence critics and people who are speaking out against you. And you do it by suing them, right? Sort of the old COS where we sued everybody and then they got their butts handed to them and now they don't sue anybody. But that was sort of the Hubbard thing for years. And then suddenly there are laws now that protect individuals and businesses from being sued for essentially a frivolous lawsuit. And as a last ditch effort, two of the defendants, Religious Technology Center, Inc. and the Church of Scientology International, not the Keebler elf himself, because he has not personally appeared. But those two legal entities filed basically an anti-SLAPP lawsuit or alleged an anti-SLAPP claim against Leah Remini, saying Leah has sued us just to shut us up because she doesn't like what we have to say. That's essentially what they pled. And then, of course, Leah through her attorneys responds, and then the church replies, and then the judge issues a tentative ruling. Now, I think it's unique to California. I've never seen it ever before until I got with you, seen a judge say, here's what I think I'm going to do, review and tell me if I'm right. So that's sort of unique to California State Court. But the document we're referring to is the tentative ruling, where the judge has given all the parties notice, unless I'm missing something. Here's what I'm going to rule. We'll have a hearing. You're welcome to try and change my mind, but here's the proposed ruling, and I don't suspect it's going to change, but you have the right to try to convince me otherwise. Okay? So
I know I keep looking like I'm about to ask you a question.
Okay.
So, I mean, to a layman, what's crazy about this is that these statutes, these anti-SLAPP statutes were put in place to prevent giant corporations like Scientology from silencing little people in lawsuits. And the irony of Scientology basically saying, what, Your Honor, I do declare we are being harassed by Leah Remini. I mean, it just seems so beyond anything that a court or a judge could take seriously. And yet, unless I'm mistaken, the judge has partially ruled in Scientology's favor. That's why I wanted to bring you on, because I wasn't totally following his ruling.
There's really no winners or losers here. So if you get sued and you believe it's a SLAPP lawsuit, you file an anti-SLAPP motion, and if you win the motion, the entire lawsuit goes away. The judge says, yes, this is frivolous. There's no basis for it. The shortest distance between here and there's a straight line. Get to walking. Okay.
And am I mistaken that if the case is thrown out based on anti-SLAPP stuff, the offending party is responsible for all the other party's legal costs?
Exactly. Then they adopt the English rule where the winning party gets their fees paid for. In most cases, even if you win, it's the American rule. I pay my attorneys if I win, and you pay your attorneys when you lose. Everybody's responsible for their own bills. Now, there are some statutes that shift that, but sort of unrelated here. And so essentially the judge said, in order for Scientology to win the anti-SLAPP, they have to win the whole thing. And so like the entire lawsuit or the portions of the lawsuit they're claiming anti-SLAPP would get chucked out wholesale. That's not what happened here. Leah Remini filed originally close to 300 paragraphs of allegations. Now, when I say paragraphs, it's a little bit misleading. Most of these are like one sentence. but each individual claim has its own paragraph. And so there could be 50 paragraphs just setting forth the facts. Here's my name. Here's where I live. I was in the church from this date to this date. And then we get into the various allegations. So all the paragraphs, they would have to be hucked out wholesale on an anti-slap for the movement to win. It's about 24 pages or so, and the judge works his way methodically through each of the claims that RTC and COS raise in their anti-slap motion. And both parties won a little bit, both parties lost a little bit, but nobody won the day.
Okay.
So the purpose of anti-slap opportunities is so that a poor run-of-the-mill average Joe who can't afford to pay a lawyer millions of dollars can resolve this quickly. But in this case, there are legitimate questions, and the judge has said some of these go away. I think the judge, by my math, I think the judge only threw out maybe 20 or 25 paragraphs. The other 270 some odd stay.
Okay.
And so Scientology won some of it because some of it went away. Leah won some of it because some of her big claims stayed. And here's the thing too, just because you plead it, which is just because you raise it in court, doesn't mean you can prove it at trial. And this is sort of a gatekeeping threshold. The judge says you have to make a sufficient allegation on its face that you can then later back up. If I just say, I don't like Aaron. Well, that's not enough. I have to say, I don't like Aaron because Aaron damaged my car because I can't just say he damaged my car.
Hey, I apologize for that.
That's okay. That's okay. And so when I make the claim that Aaron damaged my car, I have to back it up with this statement. He hit my car when I was in a parking lot. He hit my car when I made him mad or whatever, right? Some of these allegations, Leah's attorneys did not back up with evidence. That's not uncommon. You plead everything. You sue everything, including the kitchen sink, and then you figure out what you're going to win as you go. Right as we get further into this, within about a year of trial or so, there's going to be another major series of motions filed called motions for summary judgment. So this is, and they're going to look very similar to this. It's not going to be based on anti-slap. What it's going to say is discovery is closed. We've exchanged all the documents. We've taken all the depositions, and there is no evidence to support this claim. Or if you're Leah Remini, you say, here's all the evidence I have. The defendant has no evidence to contradict this. So there's no question for the jury. There's only story A. There's no story A and story B, and jury has to compare the two. There's only one story, and therefore this issue doesn't need to go to the jury. So we're going to see something
for summary judgment always happen after discovery has occurred. Meaning it would never occur before discovery has occurred.
No, because you're citing to the deposition transcripts. You're submitting evidence as part of that motion. That's not to say you couldn't, but you're not going to win. And generally speaking, I don't get to file 15 motions for summary judgment. I lost and file again. I lost, I file it again. I lost, I file it again. I normally get one time. I might get a second if I can show, Judge, here's evidence that we didn't know about until after, this person came, called us in the middle of the night 6 weeks after we filed our motion. Both sides have taken a deposition. Both sides have conducted discovery. And now this issue's before the court. So there are a few exceptions, but generally speaking, you get one swing at it.
Okay, so and the document that you and I are discussing today is the judge published his preliminary ruling. The hearing on this issue actually occurs tomorrow. Serge Del Mar will be present in court to find out what goes on in the proceedings. If this lawsuit, if Leah Remini and her lawsuit pass the anti-slap effort to get it thrown out, what other barriers exist before we can expect to see depositions start happening? Because once David Miscavage is a ruled officially served in this case, and once this case clears the anti-slap hurdle, is that when we would expect to see David Miscavage deposed? Yeah,
exactly. So discovery is sort of, traditionally it's done in multiple phases. The first is paper discovery. Paper discovery is almost worthless. Sometimes I joke that lawyers do it to put time in the billing record. But the reason we do paper discovery, most of the stuff you're going to send me is nonsensical crap I don't need anyway. But what it does is I'll ask a question like, name everybody to your knowledge who knows anything about this or has ever heard anything about this. That may include your great-grandmother who died 15 years ago. But what it does, it helps me identify the people. I already know I need to talk to 50 people. but there may be 12 or 15 or 150 more I need to depose. So it gives me an idea of who my witnesses are going to be. And it also gives me an idea of what evidence does and doesn't exist. Turn over all text messages. And then they give me something. And well, I know because I've seen my client showed me a document from a witness of a text message that the defense didn't turn over. So I need to know who has that. Paper discovery is almost worthless. There is some value to it, but it's almost worthless. The important stuff, the sexy stuff, the stuff people talk about are depositions. And that's so normally the first step of that is the written discovery component followed by depositions. You can do it in any order, but a lot of times my deposition is built around the evidence I receive through paper discovery.
That makes sense. Okay, so let's say this lawsuit clears the anti-SLAPP hurdle at tomorrow's hearing. What other arguments or motions or pleadings could Scientology have in the, pull out of their playbook to prevent moving forward to the deposition stage? Meaning, what other tactics are there to get this thrown out? Because what Scientology is definitely afraid of is the depositions. Yeah. What other strategies could they be pull out here to prevent depositions?
There's not a whole, I mean, there's going to be some procedural stuff, Judge. So most of the time, like in written discovery, the rules prescribe a timeline. Where I practice, it's 30 days. You have 30 days to respond to this written discovery. Judge, we need more time. We need 45 days. We need 90 days. We need 180 days. So they can pick up some extensions along the way. There's also going to be arguing back and forth about, oh, well, so-and-so can't sit for a deposition that day. As lawyers, we try to be professional with one another and be accommodating. But at some point, if you just become an obstructionist jerk, I will notice you for a deposition. And when you don't show up, I can ask the court to cite you for contempt. Because a notice to take deposition is what you give a party. A subpoena to appear for deposition is what you give a non-party. Both of those have the weight of the court. So if you don't show up, I get to cite you for contempt, and then you get to go in front of the judge and explain why you felt like you were too good for discovery.
Interesting. Now, if I recall correctly, and there are like 5 or 6 pending legal actions against Scientology, if I recall correctly, Leah's team has submitted a second packet of evidence to the court, to the judge, about all their efforts to serve David Miscavige. I believe we're still waiting for the judge to rule that David Miscavige has been served. Did this tentative ruling even touch on that?
No, in fact, well, the judge acknowledges, I think in a footnote at the very bottom, one of the footnotes, I think even, where it says, individual defendant David Miscavige is not party to this ruling because he has not personally appeared, meaning he has not had a lawyer enter an appearance on his behalf. But ultimately, if the court decides that the anti-SLAPP fails and Leah's case gets to go forward, which at this point it clearly appears that that's going to be the case, and I can't imagine that something's going to change in the next 24 hours. In theory, he can come and raise the same arguments, but he's going to lose because the judge is going to say the evidence hasn't changed. There's still enough there to go forward with it.
Right. Well, that's one of the things I am incredibly excited to see about tomorrow's hearing is what discussions occur between the parties about David Miscavige being served. Scientology will spare no expense to prevent David Miscavige from being deposed. Zero. There's no amount of money they will not spend to prevent David Miscavige from being deposed. And it's one of these things where I know Leah won't take a settlement. But I just feel like I have to call out the fact that Scientology will try to offer so much money that they think she'll have no choice but to offer a settlement if it will mean they can keep David Miscavige from being deposed. So this is going to get very, very exciting very fast.
Yeah, and here's the thing. Or maybe
not so fast. Who knows?
Right. And here's the thing, too. Lawyers can try all they want to stop a client from being deposed. And if he refuses to show up and they can't get him to, Leah's attorneys, when they drag the Miscavige's attorneys before the judge for failure to participate in discovery, listen, I have the right to depose him. And either you entered, this is what happened in the Alex Jones case. He refused to participate. So either put the attorneys in jail until their client shows up, which has been done before, for contempt, or enter default judgment in favor of Leah Remini, and then it goes to the jury how much, and the discovery is all about how much. It's not if she gets paid, it's how much. But here's the thing. There is now a legal judgment that David Miscavige, and if any of the other defendants refuse to cooperate, are legally responsible for this conduct. So now the legal record exists of the wrongdoing. Just because a judge defaults you for not participating doesn't mean it's not a valid judgment. It's absolutely valid. You basically gave up your right to defend yourself.
Right. By the way, anyone newly joining the stream, we've got 2,500 people watching right now. First of all, please hit that like button. Second of all, please go subscribe to your lawyer friend, Zach. He is my lawyer friend. He can be your lawyer friend too. Okay. What was there anything else that jumped out to you of particular interest in this tentative ruling?
You know, it was, there were a few things I found interesting that, so first, the judge did a fantastic job of breaking down the law and identifying, well, it's a two-prong analysis. And if Leah wins here, then it switches to the defense. And if the defense wins here, it switches back to Leah, and walking through what the evidence or what the record had shown and the evidence that was submitted in support. So I think, I don't know California law very well, but it appears to be a well-written opinion. And if taken up on appeal, I think the judge is probably going to be affirmed, which means the judge got it right. There were times where the judge sort of begrudgingly said, yeah, I have to agree with the defense here. She didn't put up any evidence, or even though the defense says there's no evidence there, clearly these acts are well beyond protected speech. It's all basically based around protected speech. Yes, normally this court and all courts in California recognize the importance of freedom of speech, but your speech can't be so egregious so as to interfere. So, for example, she had three claims about tortious interference. One was about the interference with the podcast with she and Mike Rinder. That was part of iHeartMedia. And then there were two others. One of them was about the company they had hired to manage the marketing and advertising. And then there was another one, I guess, for a project in the works. The judge says the iHeartMedia podcast gets to stay because they have statements, emails, records, whatever, from executives at iHeartMedia that were being threatened. Yes, speech is protected, but you don't get to threaten people engaged in various legal business. Okay, various business conduct that is legal. So that is absolutely a valid claim. What is not a valid claim is the fact that this deal that was being negotiated or talked about never came to fruition. Leah would have to prove that because of the actions of the defendants, this deal didn't come to fruition. And the judge even acknowledges, and this is probably unique to judges in New York and California, the entertainment industry is finicky, and any seemingly small thing could cause a deal to come off the rails. This isn't like people entering into business to buy pallets of widgets and sell pallets of widgets. Anything could tip a party to leave a deal in the entertainment business because it's all about the way people appear.
Right. You know, something just occurred to me, and I'm reminded about the lawsuit being litigated in federal district court in Tampa. It is the Baxter Paris versus David Miscavige Scientology et al. The judge had issued a ruling that lawsuit had to go into Scientology internal religious arbitration. The plaintiff's team filed a request for an interlocutory appeal. What's it called?
Interlocutory. And the judge in that case did grant it, that this is good for the plaintiffs. This is bad for Scientology. Could Scientology in this Leah Remini lawsuit do something similar to that? So that's a good question. This is based on general legal theory, not California law, because I'm not licensed in California. I haven't seen any legal issues that the judge was addressing in this motion. Because remember, the only issues addressed in this judge's order were those issues raised by Scientology, by the church, by RTC and COS Inc. or COS International. Just those two defendants. They didn't challenge the entire lawsuit because a bunch of that is legitimate. And the judge acknowledges that. But so there could be other things out there that were challenged, but then they may be challenged later, either as based on a valid legal theory or just to cause delay in the case. But I can't see a reason that this order would affect the ability to stay out of arbitration, because these are all dealing with claims directly made by Leah that happened to her, not tangentially to other people. These are all claims, and all of these are to have alleged after she left the organization, which means she's not subject to arbitration because she abandoned it anyway.
That's right. I guess what I was asking there is not whether they could make such an appeal on the grounds of arbitration, but my understanding of that procedure of an interlocutory appeal, did I say it right?
Yep, you did.
is that they're basically saying, hey, judge, this ruling that you're making, the entire case could go one way or the other, depending on whether you're getting this wrong. Can we please have permission to appeal this anti-slap motion to a higher authority? Is that a request the Scientology team can make in this situation?
Oh, possibly. And what I don't know in California is an interlocutory appeal an appeal of right or an appeal of what I call an appeal of convenience. Certain things are appealable as a matter of right. If I ask to appeal it, I get the right to appeal it. Sometimes other appeals, there has to be sometimes the Supreme Court will say, no, there's nothing for us to consider, or we don't want to take it up. So it would depend on what California, and each state identifies what can be taken up on an interlocutory basis. But I think at this point, because even if they win the anti-SLAPP, there's still legitimate underlying claims. So even if they win anti-SLAPP, parts of the lawsuit go forward. So I don't think that this, in my opinion at least, this would not be subject to an interlocutory appeal, because there are underlying claims that would survive even if the anti-SLAPP won, which it doesn't appear it's going to at this time. But even if anti-SLAPP won, there are underlying claims that would survive.
Right. Because in the same conversation that we're having about there's no amount of money Scientology will spend to keep David Miscavage out of a deposition, that there's also no amount of time they will not spend abusing and extending the legal process. That money is no option, and time is the goal. So they could appeal to the state Supreme Court. They could appeal to the U.S. Supreme Court if it's even on the table. Because if the option's on the table, you best believe that's what they're going to do, no matter how much it costs. And
what I will tell you is, in my opinion, I don't think this is even subject to U.S. Supreme Court jurisdiction.
Okay.
So there are certain things, there are certain state laws that theoretically could go to the U.S. Supreme Court, specifically state laws that infringe a person's constitutional rights. This doesn't appear to pertain to a person's constitution. Now, it may violate the state of California's constitution, but it doesn't appear to touch anything federally that would give the U.S. Supreme Court jurisdiction anyway.
Very interesting. All right, let's check some of these super chats. Gary Mackey, #retire Zach now.
Thank you, Gary.
Yes. Every time we do a chat, let's explain to people. This is Zach's viewers wanting him to make enough money on his channel that he can quit his day job.
That's the goal. Yeah, absolutely.
A virtuous goal. Okay, what's this? Valentina Creel, UNJ. Oh, you and Jordan Peterson equals my favorite superhero crossover. Yes, thank you guys. The only complaint I have about the interview that was published with me on Jordan Peterson's channel, the word Scientology doesn't appear in the title of the video. Not great for this YouTube search algorithm, in my opinion, but what do I know, guys? I grew up in a cult. Okay, RNLC for moms and babes. Question: I thought Leah has the receipts that demonstrate what Scientology has been doing to her. What more does a judge want? All right,
so I'm not sure what you mean by receipts. I assume you mean things like emails or other documents that would be evidence. It's not about what the judge wants. It's about what the law requires. And the law says, in order to sustain this cause of action, you must allege with certain particularity certain things. And if you don't allege those certain things, then you just can't win. And as a lawyer, I have to have a good faith basis to think that I can generate the evidence. So if I don't think I can generate the evidence, I may stick it in there, try to sneak it in there and hope I don't get caught. But in terms of the large scale, sometimes you're willing to lose little bitty skirmishes to win the war. And if that's what has to happen in this case, so it goes.
Very cool. Oh, I'm glad this question came up. Are cameras allowed? Yes. There will be cameras in the courtroom. Now, it will not be live streamed to the best of my knowledge, but I already know that media has been granted cameras, and I have a very strong reason to believe that we will be able to get copies of all video footage taken by the media in the courtroom. So that's going to be a huge bonus. We're going to have a lot of fun with that. Surrounded by Scientology. This is my friend Clearwater George. His channel is Surrounded by Scientology. Can't wait to get back out there in Clearwater tonight. Yes, we took the entire hotel hostage last night with merely a cell phone out front. It was incredible. What you can accomplish with SPOT superpowers is truly incredible. And we're going to be exercising those powers again this evening. So join us for that. Okay, cluttered and chaotic. First super chat. Keep doing everything you're doing. I'm so invested, although I'm a never in. Well, guys, I mean, people who've never been in Scientology form the vast, vast majority of the base of support and the viewers and everything in this movement. So thank you for everything you guys do and for watching and caring and paying attention and supporting. It really is what makes it all possible. So thank you so much. Valerie Jack, thank you very, very much. Phil Anderson, if someone made a movie about the Xenu story and did not mention Scientology, what would Scientology do? You know, this is a great question. I know they have protected, they have some sort of copyright protection, some sort of corporate trademark secret protection on the upper OT levels itself, but not on the word Xenu or the Xenu story if you don't call it Scientology. But what do I know? What do you know?
So I'm not an intellectual property attorney, but I will tell you this. From my perspective, they have two options. They could do something, such as they could file a copyright infringement suit. They could do any number of things, or they could do nothing. And the problem is it puts them between a rock and a hard place, because if you're not subject to knowledge of the confidential levels, you can't acknowledge it exists. People who have access to the confidential upper levels, if asked about it by somebody who doesn't have access to it, say, I don't know what you're talking about, never heard of it, that's not how it works. But by doing something, they acknowledge that the material is correct. And so those public members of the church who are either whether they're confidential or whether they're on the upper OT levels or not, they look at it and go, they're not allowed to acknowledge it exists. This right. So it puts them between a rock and a hard place, and they're damned if they do and they're damned if they don't.
Oh my God, I never even thought of that. So of course, if someone is out there saying, I have Scientology's secret upper level materials and this is them, these are them, then of course it still becomes an interesting argument as to, in order for Scientology to sue that guy, they would sort of have to be admitting that that was really the materials, and that becomes interesting in its own right. But if someone's not even saying this is Scientology, someone's just like, hey, I wrote a new screenplay and it's about Xenu and the Galactic Federation and the body thetans, and they never even say the word Scientology, Scientology would have to admit that that was their secret upper OT level materials in order to make claims against them, wouldn't they?
Yeah, in order to make it go away, they'd have to acknowledge that this is based on our material. And here's the thing: if they file a lawsuit for a copyright protection, they have the burden of showing that they own the copyright. And the way you show you own the copyright is you have to produce a copy of the text that's protected. Here's the upper level OT material. I showed you we owned it, and even though that would be theoretically subject to a court order, that thing would leak like a busted faucet on a cold winter day.
Oh, that would be amazing. Abigail S. Zach's Patreon is up. Please remember to sign up.
Thank you, Abigail.
Oh, very cool. That's right. Definitely check out. Is a link to your Patreon on your YouTube channel? Or?
Yeah. So right there where it says right next to Amazon, just two more links. They click that. That also brings up the merch store and the Patreon link right there.
Oh, there you go. Fantastic. All right, guys, check that out. And okay, this is something I've seen floating around the SPTV videos lately. Someone caught some Scientologist on some camera saying to someone, "Are you real?" And people are wondering, what does that mean in Scientology? Guys, to me, that means someone just slurred their words or messed up and said something and they were startled. That's not my opinion, my experience. That's not a thing Scientologists say to each other. That's not a thing. Are you real? Maybe they meant to say, are you for real? And they got startled. Someone could come up with some explanation for what this might mean. But the thing is, it's not a thing. That's just someone just slipped up. Someone done messed up. On Fleek by Sophia. Thank you. On Fleek by Sophia. All right, guys. Well, that's it on this subject for now. We will, of course, have huge updates tomorrow after the hearing. Zach, maybe we can do that together. Actually, I tell you what, maybe me, you, and Serge do a live stream together talking about this, because he's gonna be the one there present in court.
Yeah, for sure.
And
they've closed work for tomorrow because apparently it's too cold to stand around when it's the high is 8 degrees Fahrenheit. So I'll be nowhere to go in a long time to get there.
Well, thank God the proceedings are in California. All right, April in Amsterdam, AA run. When you're live on the streets, could you please recap what people you approach say to you? Can't hear anything they say. Keep up the good work. I'm loving watching you all out there. Love from Holland. You know, I'm glad you mentioned this. Someone did send me a generous donation so that I could buy some sort of directional microphone that connects to my phone so we can better hear what people are saying. And I'm still on the hunt for the right device. So, and I even asked, Chris Without a Hellcat, who's been doing some fantastic interviews out on L. Ron Hubbard Way. I said, why is it that I can hear the people you talk to so clearly? And he goes, I don't know. We're using the exact same phone. I said, you don't have some sort of external microphone or something? He's like, no, I don't. And he gave me a couple pointers, and I tried to use those pointers last night, and people still couldn't hear the people that I'm talking to. So I'm still trying to figure it out. Any of you audio wizards out there, which, I mean, Zach is one. If anyone has any tips, let me know. But we're going to keep figuring this out, guys. We're going to work out the kinks. But in the meantime, April, yeah, I will actually do a recap of what the people are saying to me. Okay, let's see. Ren B says, Slap always reminds me of briefing Oprah versus the cattle ranchers in law school. Oh, New York, TV is newer to anti-slap. Okay, I think I know what she's talking about. There was a law. The cattle ranchers sued Oprah for saying she wouldn't eat hamburger or something, right?
Yeah, something along those lines. I forget exactly, but that's a classic law school defamation, the protected speech case. It's sort of sounds and defamation plus First Amendment. It's a famous case that's covered in a couple of different law school disciplines.
Did Oprah win that one?
I was in law school so long ago, I didn't have gray in my beard, so you'll have to ask me later.
All right. Awesome, guys. Okay, that's it for now. Thank you for hanging out with us this afternoon, everyone. I got an interview coming up with Chris the Hellcat in about an hour. Stay tuned for that. Thank you, as always, to everyone who watches until the very end, and we'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe